Hello everyone, welcome to this second class of Introduction into IT Law. As we're going to talk about the General Data Protection Regulation today, because as I outlined last time, in the last class, whenever it comes to information technology, the processing of personal data, so data related to individual persons, are involved. Within the European Union and all over the Western world probably, but with different emphasis, we depart from the idea that individuals, regardless of their origin, race, religion or anything, are rational beings free to do whatever they want to do, which also entails the right to have a personal sphere, a private life protected from anyone else. That means that access to personal data and to the private sphere is something that the individual may give to other people or not give to other people. And this also applies to the state. Also, the state is only entitled to interfere with these fundamental freedoms of the individual if there is a clear legal rule and an entitlement to do so. That means that whenever the processing of personal data, and I will come back to the terms of processing and what personal data exactly means a little later on, is subject to legal rules. So that means that nobody, not the state and not any other individual, is entitled to freely process personal data of somebody else. And therefore, the General Data Protection Regulation sets up this set of rules according to which we know which personal data can be processed under which circumstances and which rights the data subject, so the person whose personal data are processed, can exercise. I will get to this General Data Protection Regulation in a minute. I just want to make sure that the legislator, and in this case it was the European Union legislator, needed to strike a balance between two contravening interests. On the one hand, in capitalist societies, as the European Union is one, we believe that human welfare resides on economic growth. And economic growth requires that the economy grows. And that means we need to make more profits, to spend more money in order to thrive with our welfare. And this also means that always new fields of business need to be explored and exploited. Like 10 years ago, the European Commission has issued a study according to which the processing of data is one of the emerging fields or one of the new fundamentals for economic growth. And if we now look at the biggest companies in this world, they're not anymore brick and mortar companies like oil companies, etc., but they're these IT companies. That means the big tech. And what do the big tech do? We talked about this in the last class too. Big tech exploits data, process data, and resell these data or like new products or services based on their data processing to other people, to other companies, and then they earn their profits with it. So in order not to hinder economic growth, the European Union needed to kind of strike the balance between the legitimate interest of the individual in having his personal data protected from interference, from outside interference, and on the other hand, not inhibiting economic growth by not allowing companies to process personal data. And this striking the balance, or this attempt to strike the balance, is reflected in the GDPR. And we are going to talk about this a little bit later, and I think then in the kind of physical class where everybody is present online, but you're present in on life, you don't listen to a recording. We're going to talk about this, whether the goal of on the one hand protecting the personal data, and on the other hand allowing economic growth by allowing the processing of personal data through private companies has been struck in a good way or not. So I would love you to listen to me, to maybe look at the legal basis. I know that most of you, or almost all of you, are not lawyers, and many of you are not, or incoming students, so you may not be familiar with the European Union's framework. So I invite you to listen to me, to look at the materials that I will have a look at with you, and then maybe to reflect on what you're listening to in order to have a chat on it when we see each other next time on site. That means you're attending a class and I'm speaking live and not recording what I do. So let's have a look at the fundamentals of the protection of personal data. And if you look at the European Union's constitutional values, that means the fundamental principles that underlie the concept of the concept of individuals living in the European Union or being in the European Union, then you will find out that there is a Charter of Fundamental Rights, which is kind of a human rights convention of the European Union, which enshrines the right to data protection in its Article 8. And if you have a close look at this provision, you will find out that according to Article 8 of the European Charter of Fundamental Rights, everyone has the right to the protection of personal data concerning him or her. And then you find another provision saying that that data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. And this is reflecting the concept of a human being that we have within the European Union. So whenever it comes to personal data, another person is only entitled to use these personal data for his or her own purposes if I consent it. So whenever a company wants to use my personal data, and even if they want to have my birth date or anything, or they want to send me an email, I need to give a clear consent, because this is a way of processing personal data. And according to the core concept of human beings in the European Union, we are free to decide on whether anybody else is allowed to use information on us or not. So first of all, you need a consent. But, well, of course, there are situations where I may not give my consent, but there is a need in the public interest for processing of personal data. And think about, for example, the police. So you know that within a society, you need a police to take care of the protection of others. And of course, people who do not behave according to the laws and who hurt other people, they can be caught by the police under certain circumstances and kind of be caught by the police, and then they will get a trial. And of course, the police needs to find out who this person is. So there's a clear legal basis. So whenever there's a law which allows, for example, a governmental body to gather information on the person, then this information can be gathered and processed even though the data subject is not giving his consent. Or for example, for taxation, all of you know that liberal democracies which do not have any natural resources to rely on, they need taxes for their appropriate functioning. And in order to raise taxes appropriately, tax authorities need to get information of the taxpayers, because it's the taxpayers who earn the money, it's the taxpayers who spend the money, and the state does not see any activity without getting information by the taxpayer. And when the taxpayer does not want to give this information to the tax authorities, they also say, despite of this, they need a means, a way to get this information, and therefore, there are clear legal rules according to which tax authorities can get the personal information without needing the consent of the taxpayer. So whenever there's a reason in the public interest and a clear rule, then there's a right to process personal data, to gather personal data, and between private parties, there needs to be clear consent. And this is laid down in the European Charter of Fundamental Rights, which applies in the entire European Union. And then, in order to make sure that this right to protection of personal data is really lived in an appropriate manner, that means executed the way it is supposed to be executed according to the constitutional basis, the European Charter of Fundamental Rights also requires that there needs to be an independent authority which ensures that the right to protection of personal data is well established in the member states. And this means, and I'll come back to that later on, that we have throughout the European Union, in all the member states, we have an independent body, an independent authority, which watches and supervises the compliance with the data protection rules. And in Austria, it's the Datenschutzbehörde. So, and you have this kind of body in every member state, and then you have a supervisory board at European Union level. But I come to the details because this is just the fundamentals, and then there's a kind of a specification of this very short article in the Human Rights Convention, in the Charter of Human Rights, and then there's a much more elaborate legislative act by the European Union, which is called the GDPR, and we're going to come to this GDPR, which is setting up more details, and we'll go into the details. But just to make sure and to show you that this is not just a European issue, it's it's not just a European issue, it's also a worldwide issue, and it will find the right to protection of private and family life, and then the right to protection of personal data almost all over the world, even in countries where we as Westerners believe that personal data are not that well protected. But there might just be other there might just be other balances or other evaluations on under which circumstances an interference with personal data, with my private life, is allowed or not. And if you look at the I need to okay, I'm sorry, I don't even know whether okay, this is still working, so I just need to okay, if you look at the European Convention of Human Rights, you know that Europe is larger than the European Union. And then there is within Europe there's a European Convention of Human Rights, and then there's the UN Convention of Human Rights, and there you will also find a hint to the protection of personal data. But this protection of personal data is part of the right to privacy, the right to protection of private and family life. And if you look at the Human Rights Convention, which is a convention at international level, and in most of the states of this world, or at least again in European states, this convention is also part of the constitutional body of a country. So like in Austria, for example, Article 8 of the European Convention, or the European Convention of Human Rights, has constitutional character. That means that any Austrian citizen, and which means any person in Austria, is entitled to require alignment with the Human Rights Convention under the Constitution. And so if you look at Article 8 of the Human Rights Convention, you will find out that according to this convention, also everyone has the right to respect for his private and family life, his home and his correspondence. And then according to the case law, that means the decisions by the Human Rights Court, which is located in Strasbourg, this right to privacy also enshrines the right to protection of personal data. And again, there is a limitation of this freedom, and this, as in the European Charter, and which says that there shall be no interference by public authority with the exercise of this right, except, and that's the exception, such as in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. That means that right to protection of private and family life is also limited to situations where there is no overriding public interest in getting information with regard to private and family life. So, for example, so when somebody has killed another person, or suspected of having killed another person, so this person is the murderer, knows whether he murdered that person or not, but the others, all those who did not take part, who were not present in the situation, they don't know, but then they need to find proof, and it may be necessary to get into the house, into the private premises of the murderer or the victim, and this of course is an interference with the right to protection of private and family life, but there is a public interest in preventing crimes and punishing crimes, and therefore under certain legal circumstances public authorities are allowed to get into the premises of a home. And the same applies, of course, to data. So let's say if we go into the data issue, because we're talking about IT law, then you know that part of our private and family life protection is also the right to have our mails, and be it like paper mails or emails, protected from the supervision or the interference by other parties. So when I write an email to another person, this email is intended to get to that other person, and nobody else except those that I allow to look at my emails is allowed to have a look at my emails. But for the sake of preventing crime or detecting crime, it might be necessary to have a look into the emails. And this is clearly an interference with the right to protection of personal data and to the right to protection of private and family life, but there's a public interest in having access to these emails. But then, of course, and that's what you see, it must be necessary in a democratic society. And then there's a lot of case law which says, well, not only necessary, the way or the interference in itself must be kind of proportionate to the aim pursued. So that means that I cannot just look into all the emails that are being sent within a country by saying, well, I need to detect crime, and therefore I need to check all the emails. You need to have a clear suspicion on a specific person in order to be entitled, and then you need, according to different legal bases, and then there are legal rules which clearly state under which conditions you can interfere with that right to having your emails protected from outside viewers. And so these are the fundamentals, and they apply in all member states of the European Union, plus for the European Convention on Human Rights, not only in the member states of the European Union, but in all the European states which adhered to the Human Rights Convention. That means like Norwegia and Switzerland, for example, are not part of the European Union, so the Human Rights Convention applies, but not the Human Charter of Fundamental Rights. But they have a similar content. And now, if you go to the General Data Protection Regulation, you will find out, and then, of course, so up to 2010, I think, around 2010, we did only have these fundamental rights enshrined in these two constitutional texts, and we did not have any European clear rules on how to deal with personal data. There were personal data protection rules within the member states, but there was no specifics. Then there was kind of a framework by the European Union, but not a regulation. And the regulation, and that's very important, a regulation at European level is a legal instrument that is directly applicable in all the member states. That means that all the member states of the European Union need to comply with that general data protection regulation. And the member states can, of course, individually maybe interpret certain provisions differently, but basically the rules are the same all over the European Union. And that is also the reason why the European Court of Justice, which is located, this one, the European Union's Court of Justice, is located in Luxembourg, can rule, or is entitled to rule on data protection regulation issues. And they can, so even if there is a data protection regulation issue between an individual and, let's say, Ireland, that the wording, that the ruling of the European Court of Justice is also applicable in Austria, because we all need to apply the same rules. So, well, I will conduct you through the data protection regulation, and since I'm a lawyer, I would like to show you how the regulation has been implemented. So we are going through the regulation, and I will show you specific rules that are important for you, just to give you an image or a picture of what's going on and how the GDPR works. On the slides that you can find online on Moodle, you will find kind of a summary or just some headlines with regard to this regulation. So let's get into the regulation and have a look at it. And now there we are. So first of all, and this is very important for non-lawyers to know, with European Union legal act, so regulation is a directly applicable European Union act. That means it applies to all the member states in the same way, and there does not need to be any implementations by the individual member states. All the member states have the same rule. And if you look at these regulations, then you will always find at the very beginning, and this is a very long beginning in this GDPR, you will find in its paragraphs, so you see it looks like this, you will find kind of preliminary remarks. So these are kind of considerations that have been made during the legislative process, but this is not the law. The law, so the binding rules, are to be found in the articles. And if you look at the GDPR, you will find a lot of considerations, because it's like 173 paragraphs of considerations before you find the articles. And we will not look at the considerations. You just need to know whatever you find, you can read in the considerations. Maybe right or not, but it's not what is binding. What is binding is only what you can find in the articles. And if there's a convergence between the articles and the considerations, then of course what you find in the considerations holds also true. But this does not, especially in the GDPR, there are some kind of, let's say, swift differences between the considerations and what you finally find in the articles, and what is binding is the articles and not the considerations. So let's have a look at the articles, and we start by the very beginning. And as I told you, so there are a lot of considerations. You see this is a lot of pages. And then let's have a look into, and we start by Article 1. The first article always say what the regulation is dealing about, and that's important. So first of all, we need to know what's the purpose of this regulation. And if you look at Article 1 of the GDPR, and we're almost there, you find out this regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data, and rules relating to the free movement of personal data. So first of all, it's the protection of personal data of natural persons. And a natural person is a human being of flesh and blood. That means basically that the GDPR does not apply to corporations, which is clear to a certain extent, because if you look at a big company, in the form which has the legal form of a corporation, then you have a lot of shareholders, and the company in itself will not have personal data. But on the other hand, if you look at the European Union's framework, you will find out that within the European Union, you can also have corporations like limited companies with only one shareholder. So legally, you have two different distinct persons. You have the corporation and the individual, the shareholder. But then, if you look at reality, then of course, if you have a 100% shareholder with his corporation, then there might be a merge between the information relating to the corporation and information relating to the natural person. So information relating to the corporation may also be information relating to the natural person. And under these circumstances, according to the case law by the European Court of Justice, there may be also a protection of the corporation for the processing of personal data, although the corporation is, formally speaking, not a natural person. But because in reality, the natural person and the corporation are that closely connected to each other that you can't make a distinction between the two. But this is just to kind of let you know. When you look at this regulation once again, then you will see, again, it's a regulation which deals with the protection of natural persons with regard to the processing of personal data on the one hand, and on the other hand, you have rules relating to the free movement of personal data. So, and there you can see already that there's the attempt to strike a balance between allowing economic growth by allowing the processing of personal data under certain circumstances and protecting the individual of his personal data being used without his consent. But if you think about a bank account, so whenever you have banks have a lot of personal information on yourself. So, if you don't pay everything in cash, then banks know a lot. They know when you buy, what you buy, they know how much money you earn, etc., etc. So, and these personal data held by banks is, of course, are precious data. That's why banks are classically subject to a very strong bank secrecy. That means that banks are not allowed to disclose any information they perceived and collected in their capacities of a bank without your consent, or unless there's a clear legal rule allowing or obliging the bank to disclose the information. But then let's assume you want to change your bank for any reason. And if there were no rules which would oblige the bank to give all the personal information to the next bank, so the free movement of personal information, if you want it, then of course that would be, again, cause troubles. And therefore, this regulation is also about this kind of processing of personal information. That means the transfer from one person to another. So, what is the material scope? And that's very important. What is the material scope? It applies to the processing of personal data which are wholly or partly processed by automated means. That means there needs to be a little bit of automation, unless, and that's the only case where the GDPR also applies, although there's no automated processing. Whenever data are collected, like manually, and then they get part of a file manually, you kind of put them into a list, then this is also within the field of application within the scope of the GDPR. And then the next question is, of course, and that's about the material and the territorial scope. What about European Union law can only apply within the European Union. But now if you think about the big tech companies, you will notice, and all of us know, that the big tech companies are mostly, at least they have their site is outside the European Union. So there is TikTok, and there is Google and Amazon and Facebook and all these companies, and all these companies process personal data. So if the GDPR did not apply, because the data processing takes place outside of the European Union, although it's European Union citizens' data that are being processed, then of course the GDPR would be a very, very weak instrument. And that's why if you read the rules on the territorial scope of the GDPR, you will find out that whenever data of European citizens are being processed, and be it inside or outside the European Union, that GDPR applies. That means that Facebook, Google, TikTok, and all these companies are also subject to the GDPR, although they may be only located outside the European Union. Okay, and then we get to Article 4 of the GDPR, which defines what we're dealing with. Because this also is very important when we talk about law. You know, we all have an understanding, or let's say there are terms where everyone has an understanding of what they may mean. And this understanding is kind of a gut feeling or like cultural understanding, blah, blah. But when it comes to law, there needs to be a clear definition, because law needs to be applied universally. And therefore, when we talk about personal data in legal terms, there must be a clear definition. And personal data is only the data that are defined as such under the GDPR. And what are personal data? If you look at the GDPR, we will find a definition in Article 4, paragraph 1, which tells us that personal data means, and that's here, any information relating to an identified or identifiable natural person. And the person whose personal data are in question is called data subject. So an identified or an identifiable person. And that means you do not necessarily need a name. But a bank account number, for example, can be related to a natural person, because that's an identifier for a natural person. Your retina scan makes you identifiable. Your fingerprint makes you identifiable. Your genetic code, of course, makes you identifiable. So all these are personal data. And then once I did research on the question whether the public key in Bitcoin transactions, and we're going to talk about this in one of the next classes, is personally considered to be personalized data, personal data. And then finally we find out it's not directly personal data, but it's pseudonymous data. And pseudonymity is something different than anonymity, because anonymous data means this is data that cannot be related to any individual. But if it's only pseudonymized, then there is an indirect way to identify the person who is behind this datum. And therefore, then it's still personal data. And then the question is, what is processing? What does processing mean? And the term of processing, they could be read in a very narrow way also, or in a broad way. And now, what counts for GDPR is the definition of the GDPR. And if we look at the definition, we find out that under Article 4, paragraph 2 of the GDPR, processing means any operation or set of operation which is performed on personal data or set of personal data, whether or not by automated means, such as, and that's now important, collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination or otherwise, making available, alignment or combination, restriction, erasure or distraction. So anything that you do with personal data, and if it's just collection and storing of personal data, is processing of personal data. So whenever, and that's even in class, when I take your names, this is processing of personal data according to the GDPR. Okay? And then there's another term which is very important, and I'll come back to it a little later on, and that's profiling. And maybe we talked about profiling in the last class when we talked about how big companies, the big tech companies, are making their profits. So if you've remembered, we talked about these kind of targeted advertising or these kind of tri-dimensional business models. That means that the big tech companies, especially the social network platforms, gather personal information. And this personal information is what we leave, the traces that we leave, the tracks that we leave on the social networks by uploading photographs and texting, etc., making information on ourselves available publicly, but also this kind of observed data. So we allow the social networks network algorithms to observe our clicking behavior, our internet surfing behavior. And with this, with all these kind of information, so they gather all the information, they know when we're being online, they know if they find out the patterns, so we may have a break every day around 12 when we get hungry or tired from working, and then we have a break and maybe we surf around and look for, I don't know, shoes. And so by observing us for a certain period of time, these algorithms will find out patterns, and they will find out, okay, there's an intent, or there's a kind of a specific love of that person, for example, for shoes, and that person usually has a break around 12, and the person, and then they can find out, but of course we need to give our age, but maybe we give a wrong age, but then by observing our surfing behavior, they may find out that we're, I don't know, in our mid-40s. And then they try to find out, and it depends on for which purposes these gathered data are processed, they may find out that we do have particular health concerns. So they profile us and find out, well, this is a person who has, I don't know, heart problems, and then they can directly target our heart problems by, for example, selling advertisements of I don't know, nutrients to us, but selling. But when they show us advertisements, it's not about, I don't know, nutrients like capsules, etc. And then they get the money by the producer or the seller of the nutrients. And this is profiling, because they make a profile out of us. Or in the Cambridge Analytica scandal, I don't know whether you've heard about this, but this is like one of the very, very previous elections in the US. There was a collaboration between one party running for election and Cambridge Analytica, which collaborated with Facebook, and which was from a prestigious British university, and they profiled the Facebook users according to their electoral preferences, and tried to indulge them, to kind of get them to vote for that particular party. And this is profiling. That out of a crowd of people, I use the information that I gathered of that people to find out about their personality. And their personality, you know, we have multiple perspectives of a personality. It can be our health, it can be our economic situation, and then that makes a difference, because you know, I will get other advertisements than a millionaire, for example, or a billionaire, because I will have other economic preferences, and therefore the billionaire would probably not be interested in very cheap products, and I will very unlikely buy a Ferrari because I can't afford it. So I won't get this information because it's very unlikely that I'm going to buy it, and then it doesn't make sense to any Ferrari seller to pay for advertisement for me. Okay, and then you have another whole bunch of definitions that I do not want to go through because I just want to give you an overview, but it's just very important to know what is personal information, what does processing of personal information mean, and what is profiling. Maybe, I don't know whether there are any data scientists among you, but of course you can anonymize personal data, and then or you kind of bundle personal data on a large group. So if you put all the personal data of a large group of people together, then they get kind of impersonal data. But if you have a certain set of impersonal data and you don't need a lot of them, you can still get back to an identifiable person. But this is still under the GDPR not considered as being personal data. So if you kind of go through statistical data and then can identify a person, then very often this is not considered to be personal data, and then it falls outside the scope of the GDPR. But again, one needs to be very careful. I once was part of a Horizon 2020, so an international research project, and there was a use case, and this use case was about, I think it was municipalities in a country. And under this use case, the municipalities would disclose the information on the income and the health situation of the administrative, so the governmental employees in the municipality. And so the municipality was that small that even though the data were anonymized, it was possible to kind of relate them to an individual person. So because if there are only, if there are only 3 people, or if there are only 20 people in public administration, and then disclosing all their kind of maternity leave, health issues, or health leaves for illness or sickness, and their income, it may be very easy, and then to find out who this person is, and then this personal data, although at first glance it seems to be non-personal data. Okay, then if you look at this all, you will find out there's a definition of genetic data, a definition of biometric data, and there's also a definition of consent. What is consent? It means that I agree. Yeah, the data subject gives a freely, means any freely given, specific, informed, and unambiguous indication that the data subject wishes that his data are being processed. And any agreement to the terms and conditions that we give in order to be able to use different tools online are considered to be free, unambiguous, and informed decisions, because we would have the opportunity to read all these terms and conditions. Whether we read it or not, this is our choice. And this is our fault if we hadn't read it. But we have been given the opportunity to read it. We needed to precisely and deliberately consent by clicking the I agree box, and therefore we gave our consent according to the GDPR. Whether this is really a free and unambiguous consent can be discussed, but from the legal design, it is conceived to be a free and deliberate choice, because we were given the opportunity to get into the details. We can't discuss them, of course. We can only refrain from agreeing, and then we're not allowed to use the service. And this is maybe could raise fairness concerns. Maybe we can discuss this in the next live class too. So, okay. And then another term that is very important is the cross-border processing is not that important. So if we have set up all the terms, so now we know what is personal data, what does processing of personal data mean, and we know that the scope of the GDPR relates to the processing of personal data by automated or semi-automated means, and we're dealing with IT law, so it's always when we use IT, then of course there is a certain degree of automation. It does not need to be fully automated, and therefore we fall within the scope of the GDPR. And now the question is, what are the principles that the GDPR sets up? And there are different principles, and the first principle is the processing of personal data must be lawful, fair, and transparent. And that means, first of all, data processing must be in line with the laws. That means basically in line with the GDPR. There must not be any discrimination, which means fairness, and it must be transparent, so everybody needs to know that his data are being processed. Then there's a so-called purpose limitation. That means that whenever data get processed, it needs to be clear for which purpose they are being processed. And there's a difference whether I collect the data just to carry out my tasks. So for example, Facebook, Google, Amazon collect the data to allow us good surfing experiences, or whether they use these data then, for example, to further process them. So maybe on another platform, or to give this data to a public entity like the tax authorities that can then, by getting the data by Facebook, check whether we filed our tax returns appropriately. So, and that purpose limitation means that when we agree to our data being processed, then we agree that our data are being processed for a certain purpose. And when our banks process our data, they do it for their banking activity, and they're not entitled to do it for anything else unless we give the consent. And this again is very important, because very often we also give the consent that the data are being used for advertisement activities. And this is, for example, today I was offered by LinkedIn kind of get a verified user, which kind of enlarges your audience, or your audience, your followers. And then I was like, okay, my LinkedIn is for university purposes, and it's good to have a big group of followers, because that could maybe attract students, blah, blah, blah. And then let's get verified. And then I went onto the website, and I came to another website, which is like some company probably collaborating with LinkedIn. And then there were the terms and conditions to agree. And the first one was that they would process my personal data in order to verify that I am who I am. And then the second box that I would have needed to click is that I allow this other company to use my biometric data for other purposes than for the verification of my LinkedIn account. And this is something that I did not agree on, because my biometrical data, that can only be my retina scan that they see through the lens, or anything else, because I don't know how they will find out about other biometric data. And I don't want them to use them for other purposes than for the verification of my LinkedIn account. So I refrained from getting a verified LinkedIn user. And of course they earn money, because this other company can then resell the information they gather, or they use it to train their artificial intelligence. And of course this is an informed consent. But, and if, of course, I'm not dependent upon being a verified LinkedIn user, and I don't depend on anything. I don't even need LinkedIn if I don't want to use it. But under other circumstances, and for example, I need Google, or at least I think I need Google, I need to give my consent in order to be able to use this tool. Or for example, for Cisco. So at University of Graz, we do have this kind of double verification in order to prevent cyber attacks on the university IT network. And for this double verification, I need to download the Cisco app in order to get that double verification code. And in order to be, and I can only download the app and run the app if I agree that Cisco gathers information on my behavior on my computer. And I need to agree, because if I don't agree, I can't access different tools on the university server. So I can't, for example, agree to certain purchases of my department I'm the head of. I can't agree to requests for holiday, or etc. And then the question is that really a fully free and unambiguous consent, or is it something else? But well, law is always trying to kind of find a compromise, and it's never perfect. So then there's another rule, which is the principle which is called data minimization. So whenever somebody collects personal data, he or she and processes personal data, needs to collect as little personal data as he or she needs to fulfill his or her task. This is especially important when it comes to governments processing personal data. So governments are not entitled to process personal data just, for the sake of having them. We never know whether we will not need them. Therefore, we gather all the personal data that we can get, even if we don't need them right now. And that's data minimization. So, for example, in Austria, anyone running a shop needs to have an electronic cash register, and this electronic cash register needs to be verified by the Austrian tax authorities. And then there are specific rules on what this certified cash register, what kind of data this certified cash register needs to collect. And if you look at the details, you will find out that you need to have this kind of use this certified electronic cash register also, not only when you sell your goods or services for cash, but also against credit card payment. And the data that are being stored in that cash register is not only the amount of money, the purchase price that you perceived, but also details about the purchaser, the buyer, if he or she has used the credit card. This is basically against the principle of data minimization, because in order to know whether the one who sold the items has filed his tax return appropriately, I do not need to know who bought the goods or services. But again, if nobody does complain a bit about it, then it's there. Okay, then of course, whenever I process data, I need to make sure that the data are accurate. And if they're not accurate, there is a right of the data subject to get this data either erased or rectified. And then there's this so-called storage limitation. Any personal data that are being processed must not be stored for a very long period. That also means that, again, I get back to tax authorities because that might be interesting, or even to shops. So all these data on your customers. Sometimes you go to a shop and the shop will tell you what you've bought like 5 years ago. This is basically not allowed. You need to erase the data after a certain period of time. And in the same row, authorities who are entitled by law to process personal data must erase these data after a certain period of time. So tax authorities cannot store all the personal data of their taxpayers for the lifetime of the taxpayer. They must erase them after a certain period of time. And there must be rules on it. In reality, there are not always rules. That's just to mention it. And then, of course, whenever somebody is entitled to process the personal data of somebody else, he must use them in a confidential and integral way. That means that he or she is not entitled to then give the data to somebody else. So if I allow my bank to use my bank account information, then I don't allow that bank to give this information to some other bank, for example. Okay. And then data processing must be lawful. And data processing is only lawful, personal data processing is only lawful, and that's the first word, if the data subject has given consent. So whenever it comes to interactions between private parties, I need to give my consent to the data processing. And you know that already now in many shops, you always need to sign that kind of data processing declaration. So you need to agree to the fact that your data are being processed. And when we're going online, we always give the consent that there's cookies to being used. And then we can say all the cookies or certain part of cookies, blah, blah. As you all know this, and this is due to this specific rule. When you don't give your consent, the other party may still process your personal data if it's necessary to start a transaction. So if they need the information on you in order to make an offer to you, then of course they can store and process the data on you. So for a hotel reservation, for example. And then the processing is necessary for compliance with the legal obligation to which the data controller is subject. The data controller is the one who processes the data, or who wants the data to be processed. That's probably the better term. The controller is the one who wants the data of being processed, because then there could be somebody else who processes the data because the controller tells him to process them. So, for example, in Austria, and not only in Austria, all over the European Union, banks are obliged to give certain information to the state, and it's certain information on foreign residents, on foreign residents, so income, capital income. So that means dividends and interest paid to people who are, for tax purposes, not resident of Austria. This information needs to be, so how much did they earn in a certain period of time? This is an information that the banks need to provide to the Austrian tax authorities. Or when there is a suspicion of money laundering or terrorism financing, banks and also lawyers and tax advisors and notaries need to provide information to official authorities. And this, of course, is something that they must do without getting the consent of the person concerned, so the so-called data subject. Even in some cases, they're even not allowed to tell the data subject, because then, of course, the data subject may run away and not be caught. But there's a legal obligation. And if there's a legal obligation, so a law which obliges somebody to give the data to someone else, then of course we do not need the consent of the data subject. It may also be necessary if the processing is necessary to protect the vital interests of the data subject. So you have a car accident on the road, yes, and you may, almost die. Then of course the information on your person and any personal information, you cannot be asked whether the personal information is to be given to the doctor. But there's a clear reason, the overriding interest in saving your life over the protection of your personal data. Processing is necessary for the performance of a task carried out in the public interest. So if the controller, again, is a public authority or carries out a task in the public interest, then there may also be, there's also a right to process personal data without the consent of the data subject. So, and then in specific member states, with this regard, there may be some additional rules which member states are allowed to have and which can differ from one each other, but this is not important for you. What is important for you is that among private parties, as a general rule, you need the consent by the private party of your data being processed. Whenever an official authority processes your personal data, there needs to be a clear legal rule, a basis that entitles that official authority to process your personal data. Without law, there is no right. That means that tax authorities cannot they cannot simply scrap the internet, or the police cannot gather all the data on speed data, etc., and store them for a long period of time in order to find out whether, or later on, whether you have transgressed the laws or not. There needs to be a clear rule, a clear law which allows authorities together to process these data. Okay, then there are of course specific rules. How do you need to consent, to give your consent, and then which needs to be clear. It needs to be clear to you that this is a consent that you give, and therefore you need to click a box, because if you click a box, and this again is psychological findings, if you actively need to click a box, then you can assume that you reflect it, whether you click the box or you don't click the box. It's not presumed or considered to be a consent if you click the box only to say no. You just really need to give your free consent. That means I click the box in order to say yes. So then there are specific rules protecting children, of course. And then there's a specific category of personal data, and this specific category of personal data is called sensitive data. So if you think about personal data, then there are different types of personal data. So there may be my bank account information. So the money I earn each month, is certainly another type of personal data than my sexual orientation. So, and if you think about different states around the world, then maybe some of you know that in Sweden it's more than common that everybody knows what his neighbor earns. In Austria we do not speak about money and we don't speak about wages, so nobody knows what the other earns. But in Sweden it's more common that this is public. Everybody knows how much money we earn a month, because this is considered to be personal information, but it's not sensitive information. But my sexual orientation, this is something very personal, very intimate. And this is something which is kind of the core part of my personality. And this sensitive information, this is information with regard, this is data on racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, genetic data, biometric data, health data, data concerning a natural person's sex life or sexual orientation. These are highly sensitive data, and the processing of this type of data is in general prohibited. That means you can process any personal data you want with the consent of the individual or by law, but with sensitive data there are additional restrictions. And the additional restrictions, because if you look at the first paragraph, then you see, well, it shall be prohibited. But that's not true, of course. There's always an exception. But the exception that you can find it in paragraph 2 of Article 9, and then you see there's a lot of exceptions when it's allowed to use sensitive data to also process sensitive data. And of course, there's again, it's allowed if you have given your explicit consent. And then again, if you think about a dating platform, if paragraph 1 was there without paragraph 2 of Article 2, then dating platforms would not be able to run their business model, because they, of course, collect a lot of personal data in order to find the perfect match. So if you give your consent, then also the sensitive data can be processed. And then, of course, they can also be processed if there is an overwhelming public interest in processing this data, and if it's really necessary for the public objective to be found. But this is really, sensitive data is the core part of a human being's personality. And you know that being in the possession of all this data would allow somebody who wants to abuse from his entitlement, to discriminate people from each other, and to do a lot of harm to individuals just because they have other political beliefs, philosophical beliefs, other religion, or etc. And that's, of course, absolutely contrary to the Human Declaration, the Universal Declaration of Human Rights, which tells us that we should not discriminate, that everybody is born equally, and that we do not consider race, gender, sexual orientation, or religion, or anything when we deal with people. So, and now, of course, if you set up rules and conditions under which personal data can be processed, then you also need to take care that those who are protected have clear rights that they can derive from their protection. And what are the rights of the data subject? First of all, they are entitled to have transparent information and communication of the way their data are being processed. And this is what we find in the terms and conditions that are issued by all the private companies where we give our consent. So we have these long terms and conditions, and if we read them carefully, we will find out what these data, our data, are being used for. So it's transparent because everybody can read it, and it's clearly communicated. And we also are informed about our rights, because there's not only the right to be informed, there's also the right, and if you want to, you can ask these companies to disclose what kind of personal data they have processed. You have the right to access your personal data that are being processed within the other company or even within a government. Maybe you know that this is not always very easy. This information is not always very easy to get, and of course it has been made rather difficult to people to get the information, but you are entitled to get the information, and if you strongly push on your rights, then you will also get the information, because that's an obligation which is enshrined in the GDPR. You also have a right to be informed about the information that has been given to somebody else or obtained from someone else. So you see there are long rules on this too. And then you have in Article 15, you see the right of access by the data subject, and then you see that what all the specific information that you can require the one who processes your data or his to disclose. And then when you find out that your data were wrong or some data are wrong, and you have a right to rectification, and you have also a right to erasure of these data. The right to be forgotten. Because this also is a general principle underlying our liberal democracies, that is, our behavior can change over time. And if our behavior can change over time, then we're entitled that certain records of our behavior be erased after a certain amount of time. And this is the right to be forgotten. And of course, if the processing is going into a direction that you did not give your consent to or did not want to give your consent to, you can also restrict the right to process. So you can kind of get back to your consent and review it to a certain extent. And then you have that right to data portability. That means, and that is my initial example, so if you want that the data that have been processed by one company get transferred to another company, then you have the right, you're entitled to require this. So your bank, and that's why when you change your bank, the two banks kind of exchange all the information, and you don't need to do anything even for your automatic payments. When you're not happy with what happens, you have the right to object. And then, and this is a very important article, that's Article 22, which is related to automated individual decision making, including profiling. So, and this is a very important provision, especially in the GovTech context. We all know that artificial intelligence is increasingly being deployed not only by private companies, but also by public authorities. And it could happen that an algorithm, an AI algorithm, profiles you in a certain way. That means that, and maybe I give you an example of a tax administration AI. So let's assume that the tax authorities, they get a lot of personal information on you through your tax files, so your tax returns, through social security information they can do internet searching, they get information by banks, they get information by, they have access to car registers and registers of immovable property, etc., etc. And so if artificial intelligence is deployed by tax authorities, these tax authorities can find patterns about taxpayers' behavior. They can compare my personal data to the data they gather from another taxpayer who is maybe in a similar situation as I am. This is called cross-checking of personal data, because then they compare my data with the data of somebody else, and then they may find out that there are kind of irregularities, because there's a pattern, say like my travel expenses are much higher than the travel expenses of a similar professor, and then the algorithm could say, well, there could be a problem, you know? And then if the algorithm takes the decision and issues a notification to me, which obliges me to pay more taxes without having a tax officer having a look, so a person, a human in the loop, having a look at the outcome, what came out of the artificial intelligence. This is called profiling, automated individual decision making, including profiling. So I was profiled first, and I could be profiled, for example, as a fraudster, somebody who frauds the laws, by the artificial intelligence, because the artificial intelligence, by kind of checking all the data and recognized, let's say, a fraud pattern, and therefore it assumes that I'm a fraudster, or more likely a fraudster than somebody else. And now it could come out that then this artificial intelligence, I can program it this way, issues a notification and asking me to pay an additional amount of taxes without a human being ever having considered the outcome of the AI and having been in contact with me. This is technically possible, but it's legally prohibited. And that's what Article 20T tells us. When we come to GovTech, I will, however, give you some hints that maybe, although it's prohibited, it takes place sometimes, and then we'll discuss whether this is a problem or not. But that's just to make sure that profiling, automated decision making, which resides on profiling, is basically prohibited unless there's an exception under paragraph 2 of Article 22. And this exception basically exists where, and among others, where there's a clear rule. And that's, for example, in Germany, the German tax authorities are entitled to do automated individual decision-making, including profiling, because there's a clear rule under German law which allows tax authorities to deploy such technical instruments. Yeah? Okay, and then, so that seems to be a rather clear framework. First of all, the processing of personal data is only allowed if there's either a clear law or a consent by the data subject, and every data subject is entitled to get informed about the data that are being processed, and is entitled to have his data erased or rectified, and to have his data, the processed data, transferred to another controller or processor. So that this seems rather clear. But then if you think about national security and other public issues, and sometimes it could be counterproductive for the public aim to tell the data subject everything about the data processing. And therefore, Article 23 of the GDPR sets up a certain type of restriction. So sometimes the rights of the data subject, so that means that the one whose personal data are being processed, are restricted. So there's no right to erasure, and sometimes there's no right to information. And this is clearly defined under Article 23. We will come back to this also when we talk about GovTech, but just to make sure, to make you aware. So if it deals with national security, then the state can say, well, I will not provide you the personal information that I'm processing on you because this is against national security. Or public security, and then, and that's very important, other important objectives of general public interest. So, for example, the Austrian tax authorities, which deploy artificial intelligence, and this is something that you can see on the internet, not in the legal rules, they assume that they do not need to perfectly inform the taxpayers about how their data processing works and what they do with their data processing tools, because it's for to uphold the financial interest of the union member of Austria. Whether this is true or not is something that we need to discuss, but at a later stage. But just to know that anything that you find in this general data protection regulation, so you have a huge bunch of rights, but these rights can be restricted under specific circumstances. And then, of course, it depends on how you interpret and you weave these specific circumstances against the personal interest in having your personal data protected. And this balance can be evaluated differently according to your political and basically political beliefs. And we're going to come back to that again at a later stage. Between private parties, there is no right to restrict these rights of data subjects. Between private parties, we're basically dealing with consent, and then there the major concern is our clicking the box really an informed consent within the idea of the protection of private or family life. But then again, if we think about the fact that economic growth is essential and that we inhibit certain business models if we're too restrictive with the entitlement to process personal data, then of course we will find out that we need to be a little bit generous. Okay, so now we've talked about basically about the scope of the GDPR, about the data subject's rights, and then of course with the rights of the data subject go along obligations of the controller and the processor. I have not gone into the details who's the controller and who's the processor. Those of you who have already dealt with GDPR know that this can be, under specific circumstances, a little bit tricky to find out who's the controller and who's the processor. The processor is the one who does the processing technically, and the controller is the one who rules or who has the kind of oversight of the processing. And they have different responsibilities, different obligations, and sometimes there might be joint controllers, so maybe two companies processing data, and they may be interrelated companies. And for those settings, there's specific rules, and they have the obligation to kind of keeping record of what they do, because of course, if there is an argument between the data subject and the controller or the processor about data processing, there must be clear, there must be documentations disclosing that the data processor and the data controller have acted in line with the rules. So, for example, they must be able to prove that they were given consent to process the data. They cannot just say, well, he clicked the box, but I didn't keep record of this box clicking and agreement to data processing. And that's what you find in Chapter 4 of the GDPR. Then bigger companies can also kind of elaborate data GDPR compliance rules, and then they can get certified because there are supervisory boards. I mentioned that at the very beginning. So there's a supervising authority in every member state, and then there's a supervisory board at European level who try to find to take care of the compliance with the GDPR. And in some areas it can be very tricky whether all you set up is in compliance with the GDPR, and for this you can kind of elaborate like guidelines, and then you can get certification of the guidelines, and then you're sure to comply with the GDPR. And this is especially important in sectors like the banking sectors or the fintech. They may need, because there's a lot of questions arising. Yes. So this is about the GDPR, and GDPR is very, very important throughout the European Union, and it's very important. And maybe what's interesting is that since the territorial scope of the GDPR is that large, that means that even if a Chinese or an American company processes personal data from European citizens and the data processing takes place outside the European Union, the GDPR applies. That means that foreign-seated, so third country-seated companies can only provide their services to European Union citizens if they comply with the GDPR. And last term, I gave a class on the deployment of artificial intelligence within tax authorities in Israel. And it was very interesting because the Israeli students told me that most Israeli companies complied with the GDPR, and that even within Israel there was kind of a framework which was similar to the European GDPR, because they cannot provide their services on the European market without complying with these rules, and that's a way to export European rules to the entire world, and that's interesting. And I would love to discuss this in a later class with you. I thank you very much for your attention. The next online session will be on the Artificial Intelligence Act, and then we'll meet in class to discuss what you've listened to. Thank you very much.